As a result of the warning that the United States Securities and Exchange Commission Wells issued against the NFT marketplace OpenSea, debates have arisen on whether or not secondary sales or securities are considered to be securities. Despite the fact that she stated that a programmatic buyer found themselves in the same position as a secondary market bidder, Judge Torres did not express any view regarding these deals. Lawyers argue that the action filed by the United States Securities and Exchange Commission against OpenSea, which asserts that non-fungible tokens are securities, is in disagreement with the most recent rulings made in cryptocurrency concerns. According to Bill Morgan, an attorney who advocates for XRP, Judge Torres of the SEC vs. Ripple made the decision that the XRP cryptocurrency has the characteristics of a security on its own. According to the judge, the cryptocurrency does not meet the Howey conditions for an investment contract because it falls short of being a contract, transaction, or scheme. The former securities lawyer for the Securities and Exchange Commission, Mark Fagel, concurred that programmatic sales certainly sound like sales on the secondary market, despite the fact that Judge Torres ignored secondary market purchases. He also discussed the votes that the SEC commissioners cast on the Ripple SEC dispute, which will remain confidential until the litigation is resolved in its entirety. In the case of CCVS Kraken, Judge Orek issued a warning to the agency about the importance of distinguishing between sales of the cryptocurrency asset and its inherent character. Additionally, in the case of the Securities and Exchange Commission versus Binance, Judge Jackson dismissed the CC's claims that sales of BUSD and secondary sales of BND on the market constitute securities. It has been interpreted that the notice from OpenSea Wells is an assault on creators and artists. All non-fungible tokens NFTs are, in essence, creative objects. This includes art collectibles, items from video games, domains, event tickets, and more. A determination must be made by the court regarding whether or not Section 5 of the Securities Act was violated, notwithstanding the fact that secondary sales are not technically securities. An explanation is provided by Ripple's Cyril Stewart Alderode as to why a case brought against OpenSea would be detrimental to the government agency. There are approximately 40 days left for the United States Securities and Exchange Commission to file a challenge against the decision regarding the remedy. There is a possibility that the government agency will contest the summary judgment that Judge Torres issued on XRP sales. In the event that the decision is challenged through an appeal, the regulator also risks the risk of the matter being brought before the Second Circuit Court. When the Second Circuit Court earlier found in favor of Coinbase that secondary market sales of cryptocurrencies are not securities, Judge Torres' decision on XRP programmatic sales got more weight than it would have otherwise. This is Coinbase. To go to announce the significant victory for the cryptocurrency business, Paul Grewal arrived at X. Because the regulator that loses to Ripple in the Second Circuit could establish a precedent that is binding on other courts, it discourages the Securities and Exchange Commission from appealing the Ripple case. In the previous 24 hours, the price of XRP has increased by more than 1%, reaching a current level of $0.57. Both the low and high for the past 24 hours are $0.566 and $0.576, respectively. The trading volume over the past 24 hours has decreased by 40%, which indicates that traders are losing interest. On the other hand, September may turn out to be a favorable month for XRP because it may experience a surge to $0.75 and could even reach $1. The foundations of Ripple remain startlingly robust, according to price forecasts for XRP, despite the possibility of an appeal in the Ripple SEC case, which can be considered unclear. In addition, an upward momentum will be brought about by a breakout as whales fill their bags. According to the information provided by CoinLast, the total open interest in XRP futures also demonstrates buying activity over the course of 24 hours. XRP futures OI increased by 3% to reach $1.10 billion. In the event that the United States Securities and Exchange Commission is successful in winning an appeal against Ripple Labs, this would be the circumstance. There is the potential for a significant reduction in the price of XRP native digital currency. In light of the ongoing legal dispute, the tweet highlights a significant decrease from its current value of $5,879.9. It also indicates that the cost span that is anticipated to be in effect ranges from $0.13 to $0.33. In light of the ongoing legal dispute between the Securities and Exchange Commission and Ripple Labs, it is helpful to investigate the ramifications of this tweet in order to fully comprehend its significance. The market for Bitcoin has been concentrating its attention mostly on this facet. Since that time, the legal matter has been brought to the forefront for the very first time almost 3 years ago. The question of whether or not XRP should be included in a digital asset that is associated with Ripple. in accordance with the laws of the United States, possess the status of an unregistered security is a controversy. It is impossible to anticipate the outcome of this case because of the likelihood that the SEC will file an appeal. Considering the continued legal uncertainty that is occurring at this time, the reactions of the market and the current fluctuating prices are observed. There is a 2-day discount on the price of XRP compared to the price from the prior day. This drop is a reflection of the market's sensitivity to changes in the legal system, as well as the possibility of fines being imposed for negative assessment of the Ripple. If the SEC appeals the decision, the market may be more likely to destroy the copy of the Ripple effect, which suggests that from its current value, the market may be more likely to destroy the copy. It is possible that the price of XRP will fall to a range of 13 cents to 33 cents. The price would drop by approximately 44 to 78 if it were to remain at this level. In this order, such a collapse would have significant repercussions for investors in terms of their financial situation. Furthermore, it would raise more general questions regarding the purpose and future of XRP within the ecosystem of cryptocurrencies. These questions would have consequences for the market that are more all-encompassing, not just for Ripple and its supporters, who are concerned that there may be a reduction in the cost of XRP prospects from the beginning of the market for digital currency. The two most important players in the Ripple payment systems are Ripple and XRP, which is used by a variety of financial companies all around the trust that people feel in these protocol requests could be compromised if XRP's price drops significantly, which would also cause more market volatility should the CC we wish to challenge the decision in July 2023 be chosen to offer a model for the control of other cryptocurrencies is increasing. The United States Securities and Exchange Commission has issued a number of court orders that have been directed against a number of businesses that deal with digital assets. Whether or not the courts finally decide to rule in favor of the action brought by Ripple and the SEC, there is a possibility that other digital currencies could be susceptible to legal challenges that are comparable to those that have been encountered by, which could result in increased market instability. One of the issues under close watch in the market for cryptocurrencies is the ongoing fight in court between Ripple Labs and the Commission on Securities and Exchanges. Given the current state of affairs, there is a significant possibility that the price of XRP will experience significant fluctuations. For the purpose of expansion, particularly in the event that the SEC successfully challenges the ruling, this content is intended to inform rather than to be taken as financial advice, therefore. It is important that you are aware that the author may have certain subjective ideas that are included in the viewpoints that are presented. Nevertheless, these points of view in this article do not reflect the consensus newspaper before selecting any readers who are interested in investing. If the reader determines what action to take, then these points of view are not representative of the tabloid. In light of this, it is strongly recommended that the reader do an exhaustive investigation. Their actions are completely independent of one another. Ria's Treasury is responsible for the destruction of $185, but the occasional tabloid does not have any liability for any financial loss that may have been incurred as a result of this risk. Ripple is said to have currencies. According to recent sources, however, the tokens that were associated with the initial account were legitimately removed throughout the process of returning the tokens. At the moment, the XRP ledger may contain any tokens on Ethereum. At the beginning of this month, Ripple began evaluating the reliability of its cryptocurrency in private beta by making use of the data that XRP offered. In light of the fact that some of the company's business associates have access to the new product, it should not come as a surprise that the minting procedure began roughly 1 week before the period under discussion, using the 185 tokens that were described earlier. The fact that this suggests that rules cannot be exchanged on markets is shocking because it means that once the period of beta testing is over, the stablecoin will finally create itself.